Hi, and thank you for choosing to view this webinar sponsored by Vamos Bem called How to Complete Your Portuguese Will, the Basics 101. My name is Joy Goldman, and I am the chairwoman for Vamos Bem, the Community for Aging and Dying Well in Portugal. And it's my honor to welcome you here for this very important webinar. Just a couple of logistics. This will be best viewed via your computer or laptop or tablet. It should not be viewed on a phone because we will be sharing slides with some depth of information and it will be hard to see on a very small screen. This is available to you through our website, and we hope that you will check back and watch this as often as you can because this is such essential information. I want to thank Jules DeMello, Peggy Bendel, who have been my partners in helping this come to fruition. And now I'll tell you just a little bit about Vamos Bem, and then we'll get into the content. So Vamos Bem is an organization that was founded in Setúbal with some of my peers in fellow immigrants. And we started in September of 2023. And when you go to our website, you can hear more about our origin story. What catapulted this work were incidents that impacted our fellow immigrants in the community that either were life-altering or life-ending events. And what we realized is that so many of us are unprepared with things like password sharing and advanced directives identifying what we want for end-of-life care. Who do we want to be responsible? And for many of us who have moved from other countries, we might not have as easy access to family and friends as we have in the past. So this is really important so that our welfare, our lives, how we die, and our financial assets and property can all be taken care of. Our mission in Vamos Bem is we support those living in Portugal and aging and dying well with dignity and peace of mind. We provide compassionate support, unwavering advocacy, and meaningful engagement to foster a strong community that honors each individual's health journey. And while this is easy to read on a page, this was an evolution and much dialogue to come up with what we really felt was the essence of what we wanted to create. We want compassion, we want courage, and we want your individual preferences to be honored. You can find out more at www.vamosbem.pt. Vamos Bem in Portuguese means to go well. And it was really important to us to choose a Portuguese term and one that was symbolic for going well in life and going well in death. We've already done a lot of work. We have an emergency checklist on our website, Facebook page, where you can use that tool to make sure that should something unpredictable happen to you, things would be taken care of. So that's all I'm going to say about Vamos Bem and our organization. And we can only do this webinar through the gracious and generosity of our partners at Pinto Cardosa, Fuseta de Ponte, right here in Setúbal. And some of us have worked with Pinto Cardosa, Fuseta de Ponte, with Luis, with Sophia, with Beatrice, and now Miguel. And just to tell you a little bit about them, Sofia Pinto Cardosa is an advogada, lawyer, registered in the Portuguese Bar Association since 1998. Luis Fuseta de Ponte is an advogado, registered also in the Portuguese Bar Association since 1988. This year, he also became the president of the Association of Homeowners of Setúbal since March. Beatriz Nunes de Faria, advogada, registered in the Portuguese Bar Association since 2022, and the newest member of the team, Miguel Vieira de Ponte. Yes, there is a relationship. Advogado estagiário, testing my Portuguese here, trainee, registered in the Portuguese Bar since this year, and we are thrilled to have his support as well. This is, and you can see in the background of this wallpaper, these law texts. This is a long established family business since 1898, and they have lived and supported Setúbal for well over a century. So truly, it's an honor to partner with them. They are experts in what they do, and we are benefiting from their expertise around creating a Portuguese will. So what will you learn today? You will learn basics. And we emphasize that because this is such complex information and very much dependent on your unique circumstances. So we will talk about succession and how things are done in Portugal and how we can integrate with wills that exist in other countries. And for sure, we probably will not answer all your questions. We did ask prior to putting this webinar together 4 questions that people had, and we are trying to address most of them, and there will be more. So it will be up to you to contact whether it's a notary, a law firm that you prefer to help support you in making your will happen. We will talk about, because it is so unique to Portugal, interstate succession, forced heirship, Portuguese wills and foreign wills, how we can integrate them. And then some people sometimes get confused with, well, isn't a living will the same as a Portuguese will? And actually, that is not true. And a living will, also termed advance directive, is unique, and we will learn a little bit about that. So my first question to our experts: how does inheritance law in Portugal work, especially compared to common law countries?
Thank you for having us. It's a very commendable initiative that it's a pleasure to be with you and try to answer your question. First of all, I'd like to refer that this presentation is just for informational purposes only and does not constitute legal advice. This is very important indeed. Listeners should always seek professional advice for their individual circumstances, which are always different. Now, going back to your question. In Portugal, inheritance works differently from what you may know in common law countries. We have a very strict and imperative regime that, in our experience, it would be good to try to avoid if possible. Here we have something called forced heirs. This means that certain family members, the spouse, the children, and if there are no children, the parents, must, by law, imperatively receive part of the estate. So you cannot leave everything, all the assets, to a friend or a charity. Between half and 2/3 of your estate must go to these family members. If there is no will, which happens more than it should, in our opinion, everything goes automatically to these relatives. If they do not exist, then it goes to more distant relatives like uncles or cousins, and only in the last case to the state. But these more distant relatives and the state are not forced heirs, so they can be excluded if there is a will. And at the same time, it's also possible to dispose over a certain portions of the assets, like said before, and even with forced heirs. There is also an important European rule that you should comply with, but we would like to inform you about. And if you don't make a will choosing the law of your nationality, the law that applies is the law of your last place of residence, or for real estate, the law of the country where the property is located. So you can have a certain degree of freedom choosing the law applicable. This means that if you live in Portugal or own a house here, Portuguese inheritance law will subsidiary apply. And you must check the possibilities of accepting or escaping this regime in accordance with your will. That is why we think it's better to make a will. In that will, they can choose. You can choose the law of your nationality, which often gives you more freedom to decide how the estate should be divided. Also, other advantages are the possibility of leaving the assets to people who are not forced heirs and or protect certain heir and also avoid complex and bureaucratic procedures for the heirs. So making a will facilitate all the procedures after you die.
Thank you, Luis, for explaining that complex information in a way that we can understand. So now we're going to talk about a variety of situations. And the first question that I'm going to ask is, does the spouse have any presumed legal right of priority access to assets, whether common or personal?
Hi, Joy. Thank you for your invitation. In Portugal, the spouses does not have a general priority right over all the couple assets, whether joint or personal. Here's how it works. For joint assets, the surviving spouse keeps their half and also inherits a share of the other half. For the deceased's personal assets, the spouse usually has no automatic right. But there is one very important exception, the family home. Even if the house only belonged to the deceased, the surviving spouse has a lifelong right to live there and to use the furniture inside. This right counts as part of their inheritance share if its value fits within that share. All is settled. If it's worth more, the spouse must compensate the other heirs.
Must this right be declared, particularly when the spouses have different surnames?
No. The law gives this right automatically. Different surnames make no difference at all.
What is the proper procedure to ensure the regular transmission of assets?
After death, the heirs are formally declared in a legal process called in Portugal habilitação de herdeiros. The death is registered with the authorities and then the assets are divided, either by agreement or by court decision. Until everything is divided, one person, usually the surviving spouse, manages the estate. That person is called, in Portugal, the cabeça de casal. And, of course, through a will, extra rights can be granted to the spouse if the deceased wanted.
Are there specific laws on intergenerational transmission of assets, particularly with respect to property abroad?
Yes. In Portugal, there are very clear rules on succession. and the situation becomes particularly relevant where foreigner assets are involved. We follow the European Succession Regulation. It says that normally the law of the last habitual residence applies for the all inherents. For example, a German living in Portugal dies. Portuguese law applies to all their assets, even those in Germany, unless they wrote a will saying they wanted German law instead. If they also owned a house in London, things change. The United Kingdom doesn't follow the EU regulation, so English law applies to that house. In practice, you can end up with two sets of rules: Portuguese law for assets here and in the UA, and local law for assets outside the EU. Sometimes the results are very different. Portugal protects forced heirs like children and spouses, while countries like England allow almost complete freedom in wills. That's why estate planning is key. Often, the best solution is to make wills in different countries, coordinated so everything works smoothly.
You know, my husband and I have thought of this possibility frequently as we have traveled and as we hear about plane accidents. We've thought of this question, which is, how is the situation of simultaneous death treated in Portugal?
Portuguese law has a rule called comoriência. If people die in the same event, and we can tell who died first, the law pretends they died at the same time. The result, they don't inherit from each other. Their estates go straight to their own heirs. Example, a couple dies in an accident. Instead of the husband inheriting from the wife and then passing everything to the kids, and vice versa, each inheritance goes directly to the children. If, however, it is established that one person died even 1 minute before the other, there is no comoriência, and succession applies in the usual way.
What happens if the deceased was single or divorced and owned property in Portugal?
If a person was single or divorced and had habitual resident in Portugal, Portuguese law applies to his or her succession. This means there is a fixed order of heirs. Children first. If no children, then parents or grandparents. If none, then brothers, nephews, uncles, cousins, up to the fourth degree. And only if there's no family at all, the state goes to the Portuguese state. Of course, with a will, things can change, but always within the limits of the law.
With complex family makeups, this question is important in that, do stepchildren have inheritance rights?
No, stepchildren don't count as heirs under Portuguese law. They only inherit if there's a will that includes them, and even then, only from the free part of the inheritance, the part not reserved for children, parents, or spouse.
Well, thank you for explaining all that information. So now we're going to move to how we can integrate a foreign country will with a Portuguese will. And so this question pertains to, do I even need one? Do I need both a Portuguese will if I already have a will in my other country?
Good question, Joy. If you own property or bank accounts in Portugal, foreign will may not work unless it clearly states which country's law applies, and it's properly notarized, apostilled, translated, and registered.
So what happens if I die before making a will in Portugal and have assets here?
Okay, Joy, this is a very complex answer that really depends on the case. But in general terms, the heirs, according to the foreign will, have to bring the will to the knowledge of the Portuguese authorities. Here we have two options. One, or the foreign will is considered valid in Portugal and it fully applies here, or two, the foreign will is not valid for formal or material reasons, and the succession will follow the rules of the applicable law that probably will be the Portuguese law.
In what situations would the foreign will not be valid in Portugal?
So the foreign will may not be valid for formal or material reasons. If the foreign will does not define that certain law is applicable to the succession and the Portuguese law is applicable, the foreign will only be valid if it complies with the Portuguese law. This is why it's very important, as we already explained, to choose the applicable law in the will. On the other hand, this was the material reasons. On the other hand, we have the formal reasons, because if the will does not comply with certain formalities, it may also not be valid in Portugal. A will made abroad only takes effect in Portugal if it follows the proper formal rules for being written or approved. This formality is important because the law requires that the will be validated by an authority that can guarantee its authenticity, usually through a notary or another official with similar powers, so that the document is officially recognized as genuine.
Thank you for sharing that information. It was new to me to learn that we had to get the will from another country apostilled in that country. So such important information. Thank you. So what are the legal procedures for a foreign will to be registered in Portugal?
So it's possible to register a foreign will in Portugal without making a new one. Please bear in mind that if the will is done in a country member of the EU, the procedure may be simpler than what I'm going to describe. First, you need to confirm the validity of the US state where it was made. And I'm considering for this answer, for example, the USA. The will must comply with that state's legal requirements or that country, like number of witnesses, the signatures, notarization if required, etc. Also, it requests certified copies of the will from the US authorities or another country stating that the copy is true to the original document. Second, you need an apostille. You need to obtain an apostille from the country clerk or other competent authorities in the state where it was state or country where it was signed. This replaces any need for consular legalization. Third, you need to translate in Portugal. So the official translation must be done by a certified translator in Portugal who will certify the translation and confirm that it matches the original. Fourth step is to register and open the will in Portugal. You take the apostille will, the certified Portuguese translation, to a Portuguese notary. The notary will then deposit it and register it in the National Will Register, Registro Nacional de Testamentos. In practical terms, doing a new will in Portugal with the same content of the foreign will is simpler and easier than to register the foreign will in Portugal with all the steps that I stated before. So that's why we recommend it.
Some of us have moved around a fair amount, and we have assets in different countries. So do we need separate wills for each country that we hold assets in? For example, perhaps Canada and Portugal?
We strongly advise that you have it, because if not, the legal procedures are much more difficult to the heirs after your death, as they will have to ask for a formal recognition of the foreign will in the country where there's no will, for example, in Portugal. And in that case, applicable law problems may arise, as we already described.
If your assets are possessions such as furniture, art, jewelry, a car, but not a home, how is that property valued and distributed?
Things like furniture, art, or a car are treated as part of your estate, just like a house or a bank account. They are given a reasonable value, either agreed by the heirs or set by an independent expert, if there's no agreement. And then they will either pass to the heirs or sold so the money can be shared.
Can property be put into something akin to a trust?
In Portugal, it is not possible to create a trust in the same way as in common law countries, such as the USA, UK, or Canada, because the Portuguese legal system, based on civil law, does not recognize the legal concept of a trust. However, Portugal can recognize trusts created abroad if the trust is valid under the law of the country where it was established, and that country recognizes trusts. Portugal can recognize its effects. For example, for administering or transferring assets located in Portugal.
Will a joint bank account be frozen upon the death of one spouse? We have heard that, and your response is really important to us. So if that's true, how does the surviving spouse proceed? Should we all have individual accounts as well as joint accounts?
Banks normally block accounts once they are informed of a death. However, if the account is joint, the surviving account holder can ask the bank to release it and regain full access. If the account belongs only to the deceased, it will remain frozen, and the heirs must present the legal documents to access the fund.
What if your only property in Portugal is a bank account? Do I still need a will?
A will is always important if you have any kind of assets in Portugal. It allows you to nominate a beneficiary, especially if you do not have legal heirs. Without heirs, either appointed or legal, the money will go to the state.
Who keeps the will in Portugal?
The original is kept at the notary's office and can only be disclosed to its author or after death upon presentation of the death certificate. It is also recorded in the National Will Registry, which confirms that a person has a will, but not its content. With the death certificate, heirs can find out which notary holds it.
Can foreigners make a will in English and file that in Portugal?
No, it must be in Portuguese, but a certified translator must be present so you fully understand what you're signing.
Do I need to appoint an executor of the will? That's common practice in some other countries. Do I need to do that here?
It's optional. If you don't, the heirs handle the estate themselves. Under Portuguese law, the oldest heir acts as the administrator until the estate is divided.
And can my executor, should I name one, be a foreigner?
Yes, the executor does not have to be Portuguese.
We've heard that for people to inherit property, they have to have a NIF. So this is a question we have. Do executors or heirs need a Portuguese tax number known as a NIF?
Executors, no. Beneficiaries, yes, if there are assets in Portugal.
Is the Advance Medical Directive a separate document or part of a will?
The will and the Advanced Medical Directive are different documents. The will regulates legal situations that happen after death, while the AMD regulates situations that happen before death. For example, when a person cannot make clinical decisions for themselves. The AMD sets out who should make decisions, in what circumstances, and which treatments should or should not be administered. Since a will remains secret until the time of death, it is not appropriate to regulate such medical matters. The AMD has its own framework and is registered in a Ministry of Health database, so doctors can immediately access it and contact the appointed healthcare proxy if necessary. For these reasons, there should always be both a will and an AMD.
And some of us are concerned about what happens to our body after we die. Many of us are concerned. So what happens if the deceased says nothing about being cremated or buried?
Portuguese law does not have a specific rule. In that case, the family decides whether the person is buried or cremated.
Phew, so what's next? It's a lot, huh? So breathe, for sure. And you may need to watch this again. The reason we did it as a webinar was so that you can watch it as many times as you would like before you take action. I definitely want to thank our experts, Sophia, Luis, Beatrice, Miguel. We couldn't do this without you, and your attention to detail, your partnership throughout all of this has been stellar. Thank you. So as the viewer, now is your time to synthesize this information, reach out to people here and back in your home country who can help support you, and then choose a notary and/or lawyers who you feel comfortable with to help make this happen. Action is important, and some of these protocols, like creating a will or an advance directive, what to do in the case of where you can't communicate, are easy to put off. So sometimes having accountability partners can help you get things done. And what's most important here is that you get this done so that your assets are protected and go where you want them to go. We're also encouraging you to review this information on a regular basis, meaning review your will and what you have in place. In Portugal, when you file an advance directive, it's good for 5 years, meaning it's a forced way that you have to look at and review every 5 years. Is everything I've said still relevant? Things change, life happens. So create a process, be it annual, every 2 years, where you're looking at this information and updating it as necessary. So finally, here's our contact information, both for the lawyers and for me. We encourage you to reach out with any questions. We thank you for tuning in. And I have to end with the command of the organization's name, which is Vamos Bem, go well. Thank you.